Good evening and welcome to the February 13th, 2017 work session of the Mayor and City Council. Tonight we have one item of discussion on our agenda. It's about regulations for small cell facilities and distributed antenna systems. Before we get into the staff presentation, our colleague Neil Harris was called away to be out of town for business and sent a statement that he asked that we read, and so I'm going to go ahead and read his statement, and then we'll move on with the work session. Neil says, "I'm sorry I'm unable to attend tonight's meeting, but I am in a business meeting out of town. I wanted to make sure I asked some key questions related to the proposed plans for small cell towers. As a computer technology professional going all the way back to the heyday of Commodore and Atari, I've seen many technologies come and go, and seen many that never made it out of R&D labs. In wireless alone, recent examples include WiMAX, TD, CDMA, and Qualcomm UMB. At one time, many people in the industry were excited by each of these, but I expect that most people in the meeting never heard of them because they never made it into production. Reading the technical specification for the proposed 5G cellular technology, I wonder how practical it will be in the real world. The proposed standard provides a great increase in speed, but the signal travels such a short distance that it will require an immense number of small cell towers to be able to provide service coverage. So my question to the vendors today is, how practical is this? Is there any reason to believe that 5G technology will actually launch by way of many thousands of small cell towers, or will there be another approach that is easier and less disruptive? When will we know? And if this is as uncertain as it looks from initial research, why would Gaithersburg want to proceed with rolling this out? Could we end up with a giant collection of towers that don't end up serving any purpose? It seems to me that this is a risky approach to an unlikely technology rollout. Please let us know why the small cell tower approach for 5G makes more sense than it appears to at this time." So that's the statement Neil has left us with. And I also wanted to note that in the audience we have Kevin Mack, who's representing Congressman Delaney's office, and Kevin presented us with a letter that Congressman Delaney is sending to the chair of the FCC, and if Kevin or Congressman Delaney want to explain that at some time, we'll have an opportunity later in the meeting. But now let's go on to our staff presentation. At the table tonight, we have our City Attorney Lynn Board. We have our outside counsel Joseph Van Eaton from Best and Krieger, and we have Deputy City Manager Dennis Enslinger. Lynn, take it away.
Thank you, Mayor. This evening we do have a presentation on the small cell facilities in the public right-of-way, and we wanted to start this with a little bit of background information. As you all know, we were before you in April of 2016, so some of this is going to be a little bit repetitive, but we at least wanted to give a brief overview of some of the issues before we get into some more of the substantive issues that we're going to be talking about this evening. So certainly, as you all are aware, in Gaithersburg as well as across the state of Maryland, there have been an increasing demand for the installation of small cell facilities in public rights-of-way. You know, we've seen that here, and again, we've had feedback from jurisdictions all over the state as well as the country that they are seeing increasing demands for this. Part of this is given current technology, as well as I think is what was addressed in Neil's comments, the fact that there may be a move to 5G in the not too distant future. And again, I don't know exactly how that. I think 2020 is kind of the earliest date that we've heard for that, but how the actual implementation rolls out, we don't know at this point in time. So we recognize that local governments do benefit from better wireless service. I think all of us, probably all of you on the dais, have your cell phones and like the service that you get, but we also understand that we need to balance that with the needs of our neighborhoods so that there is a sensible method for deployment here. So just again, as a brief chronology of events, in 2015, the city received its first inquiries regarding the installation of small cell facilities in its public rights-of-way. And I do want to state that at the present time, we currently have no applications for small cell facilities. Staff developed a right of entry agreement, and that was discussed in great detail at the April 11th, 2016 work session, but since that agreement was never approved by the mayor and council, that's not a binding agreement on the city. So since that work session, staff has met with community representatives, and that occurred on July 13th of 2016. We did also have discussion with at least one of the vendors, Crown Castle. There was a meeting with that group on November 2nd. And as the council is aware that not too long after the April 16th meeting, we did retain outside counsel on this issue, Joe, who is sitting here with me. So staff, through this process, began to work with the providers to see what might work for them, and then also what's going to be feasible for our communities. Staff is looking for a standard that can be applied consistently for all cell facilities, but a lot of the difficulties that we have is a lot of our areas in the city are not what we would consider equal. You certainly have residential communities that have all of the utilities undergrounded, and then we have others such as Old Town and commercial areas where an aerial deployment on an existing pole might make more sense. So these are some of the issues that staff was seeking guidance for in the April 2016 work session. I think we realized we kind of jumped ahead to too far.
Pause for just 1 second, Lynn. Chris,
I'm not seeing it.
okay. I was going to say, we haven't seen any of the PowerPoints.
Okay,
I just want
that's
to...
fine.
I'm seeing it here, but it's not coming upstairs. So I'm just gonna double check.
We haven't seen it on this
I
mod.
mean, I
Yeah.
just flipped it, okay, I'll flip it over for you guys.
Okay,
I'm trying.
great. Thank you. Go ahead, Lynn. Sorry about that.
All right, no problem. So, I mean, I think what we realized for the initial work session, we kind of jumped too far ahead where we needed to take some initial steps back to kind of build our framework for how these are to go forward before we get into some of like the nitty-gritty details of how it will actually be implemented. So that is really what we are looking for this evening. So this evening we're looking for some overall guidance on some of our policies and practices, and you'll see as we get to the end of the PowerPoint some suggested dates. We would also anticipate having another work session. It looks like that would probably be in the May timeframe to talk about some of the more technical regulations as to kind of getting down into the nitty-gritty of implementation. But that would be after we have kind of set the framework with a right of entry agreement, as well as possibly some ordinance amendments. So again, just kind of to give that a little bit historical perspective, these are some of the slides that were shown at the May work session, and these were proposed installations for residential areas. These were some proposed installations for commercial areas. And then we've put in just some other examples from other jurisdictions. This is an installation that exists. This is one in Baltimore City where you can see the slide on the left is the before picture, the slide on the right is the after picture. This was an installation that went up without any notice, without any permits. It actually blocked the public right-of-way from being ADA accessible. There wasn't the 4 feet required clear space. There were citations issued, and this one was removed in Baltimore. So we wanted to, again, do just a very brief overview of the federal regulations and FCC orders. And it is certainly not the intent of this, again, I stress very brief overview, to go into a comprehensive discussion of all the law regarding small cell facilities. We could be here probably for several days if we wanted to do that. But again, these are just kind of a little bit of reminder of some of the framework in which we are working under. Certainly, we cannot adopt a regulation which would effectively prohibit wireless anywhere in the city. That's one of the, the certainly very clear guidance that's come through the existing FCC regulations. We also cannot unreasonably discriminate amongst providers who provide functionally equivalent services. The FCC framework has provided what they've determined a reasonable period of time for approval, and that can be between 60 and 150 days, again, depending on the type of application that we would receive. If
Lynn, if you don't mind, can you put that into presentation view?
Sure.
It just may be easier for people in the public to read it.
Here we go.
There's an icon at the very bottom.
Right.
It should be.
Bottom to the right.
Next to the magnifying.
Yeah.
Just almost, there you go.
Almost.
You know,
Up.
1 inch.
Go up. Now to the left.
There you go.
Yeah.
Slideshow, here we go.
There you go.
Thank you.
All right.
Thank you.
Let the government officials take the screw
Should have put my glasses on for that one.
Answer's 3.
Hard for me to see those little icons without my glasses on.
Yes,
Anyway,
understand.
so we were talking about the reasonable timeframes, and those can be between 60 and 150 days, depending on the type of installation. Denials have to be in writing, and they have to be supported by substantial evidence in the written record. We've talked before about the RF standards, that you really can't not consider the RF standards as part of whether to approve or deny an application. And also that the FCC rules do not apply when the government is acting in proprietary function. That means if a proposed installation is on a city building or facility, we have more leeway there, because at that point we are the property owner. That's different for the public right-of-way. But for example, you all have approved different installations on like lighting in Kelly Park and other areas, and so these rules do not apply to those types of applications. And I'm going to turn it over to Joe for just a minute to let him expand as he sees fit on kind of the overview, and if there's anything that he wants to add.
Now, let me just, there's actually several provisions of federal law that come into play here. One is 47 U.S.C. 332C7, which deals with installation of personal wireless facilities, and with significant changes to existing personal wireless facilities. Under that provision, you have very broad authority to act. You're right, as long as you follow the standards that Lynn's gone over.
Can you explain a personal wireless facility? What does that
A
mean?
personal wireless services, you can think of it as your cell phone service, but it would include basically a number of licensed FCC services that we think of as cell phone service, but it would include a service that would be delivered to a tablet over a 3G or 4G or anything like that. It's there are some services that aren't personal wireless services, but what you're getting are requests for facilities that will be used to provide what are called personal wireless services. Okay, the key here, I think, is the key thing about the FCC rules generally on this first standard, the first step about the installation, is while you have broad authority, what the FCC doesn't want to allow is significant gaps in service. So when we talk about prohibition, one of the things that you're prevented from doing is obviously saying no cell phones in my community. But most communities don't do that. They want the cell phones. Where the real issue is are you effectively prohibiting that? And when the courts are looking at what's effectively prohibited, they tend to look and see, are we creating a problem in terms of the delivery of services to areas? For example, are we preventing people who are going by on a highway from getting emergency communications? Are we creating these sort of gaps so that essential services aren't getting out to the public? That's one issue that comes up. The other issue that comes up when you're thinking about are you effectively prohibiting it is, has the provider come forward and tried to come up with the least intrusive alternative for deploying their services? And different communities can come to a different answer as to what's the least intrusive alternative. And that's one of the things you can do, you can try to define through your right-of-way use agreements or through through zoning or land use requirements. The second provision of federal law that's important deals with expansions that the FCC has deemed not significant. That is, you have to approve changes to facilities if they don't substantially change the physical dimensions of those facilities. Unfortunately, the way the FCC has defined a substantial change, it looks pretty substantial when you think about it in front of somebody's house. A existing facility can go up in height by 10 feet. You can add a 6-foot appurtenance to the side of something, and that all would have to be approved by the local government unless you're talking about stealth facilities or concealed facilities. So one of the challenges created by federal rules is coming up with a set of standards that not only govern the initial placement, but that also protect against unwarranted expansions, particularly in residential areas.
Joe, can I ask a question? I know we're trying not to get too far in the weeds on the law, but in reading the packet tonight, it just was kind of a little head scratcher reading the FCC rulemaking request from Mobilite. It seemed like the FCC was interpreting the prohibition or effective prohibition of wireless services to apply to an entity, not necessarily the coverage. So it wasn't the question of, is there cell service in this area, but it seemed that they were interpreting it as, is this company able to provide cell services in this area? Can you expand or reconcile that, or tell me if your view of what the FCC's interpretation is?
Yeah, so I mean, I think it's easiest to explain that historically, when the FCC when the courts first began dealing with the wireless provisions of the Communications Act, some courts said it's enough if there is one provider in a community providing service. So if you already have cell phone coverage in an area and somebody wants to come in and put up a new tower, you don't have to let them in because the community's already got service. The FCC has said no, the purpose of the law is to promote competition in the provision of wireless services. So we don't just look at whether you have some service available in the community. You actually look on a provider by provider basis to see whether that provider can serve the community.
Provider or carrier?
Provider, a carrier, a person who's actually providing the wireless service, as opposed to a company like a Crown Castle or an Extenet that builds the facilities and then leases them to the providers of the service.
And if I may just piggyback off of that, I mean, there's no threshold here in terms of the number of providers, the definition of competition, like there might be an antitrust law, for example. In other words, if there's already 3 providers out there as opposed to 1, and a 4th wants to come in, FCC rules are still going to look at whether that 4th is allowed to provide?
Well, that's a question that hasn't been fully answered, I think, but there's only 4 entities that actually hold the frequencies that are used in the provision of personal wireless service in the U.S. Some companies lease from them, but the only people who are out there, the only entities that are actually out there generally providing the service will be Sprint, T-Mobile, Verizon, and AT&T, the wireless divisions of those companies.
Okay.
So I think we've jumped ahead a little bit to the next slide.
Sorry, Lynn.
That's okay, no problem. So we have 4 topics that we're going to talk about today. The first being the FCC potential rulemaking, which I think we've already broached a little bit. Then we want to talk about potential challenge to the Maryland Public Service Commission, and then the terms of a right of entry franchise agreement, and then potential zoning regulations. So we will jump into those. As I think is evident from your earlier questions, on December 22nd, the FCC did issue a notice of potential rulemaking. This was in response to a petition that was filed by Mobilite, and the FCC has indicated that it intended to consider actions to expedite the employment of wireless infrastructure. So there are a number of possible outcomes that could occur out of this proceeding. It could shorten the time that we already have. We talked about earlier, currently there's that 60 to 150 days once an application is received. The FCC could possibly shorten that time even further. There could also be an outcome that would allow use of the right-of-way without any or very limited restrictions, to limit even more than what is currently today, what a municipality could do to have control over its right-of-way. Another big issue is fees, where it could limit or eliminate the use of fees for the right-of-way and also for other properties. So this could impact the other facilities, for example, the lights at Kelly Park and those types of facilities, where the city is actually the owner of those properties. So as you're aware, originally comments were due by February 6th, and that's now been extended out to February 8th.
March 8th.
March 8th.
March 8th, sorry. So in response to this, the mayor and council did authorize me to move forward with Gaithersburg preparing an opposition. And then we also did outreach to a number of Maryland communities to spearhead what we now are calling the Maryland Coalition. So to date, I want to just run through very quickly of the participants in the Maryland Coalition, and Best and Krieger, Joe's firm, is representing the coalition and will be providing response to the FCC on behalf of that coalition. Currently, the jurisdictions in Maryland that are participating, and this is alphabetically, are Aberdeen, Berlin, Capitol Heights, College Park, Frederick, Gaithersburg, Greenbelt, Hancock, Havre de Grace, La Plata, New Carrollton, Perryville, Pocomoke City, Poolsville, Riverdale Park, Rockville, and University Park. And the Montgomery County is also participating as a county. We do have 4 other jurisdictions, which are Berlin Heights, Chesapeake Beach, Salisbury, and Laurel, that their councils will be considering joining the coalition this week at their various council meetings.
Did you say Bowie or Annapolis? I don't know.
We have not heard back from Annapolis at all. Bowie is having some consideration, but we don't know whether they're going to join yet or not. The other jurisdictions who have their councils haven't taken final action have pretty much indicated that they would be participating. We've also had contact with Baltimore City, Prince George's County, and Anne Arundel County, and they may be joining as well.
So, Lynn, with the mayor's indulgence, I think it's important to allow you to pat yourself on the back here and talk a little bit more about the Maryland Coalition, your involvement, significant involvement in it, how it's grown, if you want to.
Sure. This originally came out as an idea of actually more of a financial concern. I knew that the city was going to participate, and I was looking to, I have a very limited outside council budget, so I was looking to kind of share some of the costs with others. So we started with some outreach through the Maryland Municipal League, and we've probably had 5 or 6 conference calls with different groups. It's been in the MML newsletter. It's been through the Maryland Municipal Attorneys Association. So really, I've been the person who's done the outreach and gotten this coalition together. I think Joe owes me a finder fee for all this, but we'll talk about that.
She's kidding about that.
I am, yeah, that is
She's kidding
a joke,
about that.
entirely a joke. But I also do want to say, in addition to the Maryland Coalition, Joe has been hard at work, and we do have other municipalities who will be joining this effort, including Ann Arbor, Michigan, Boston, Massachusetts, Cary, North Carolina, Dallas, Texas, and there's a group that's representing a number of municipal leagues in Michigan. We'll have McAllen, Texas, Myrtle Beach, South Carolina, Portland, Oregon, and the Texas Concerned Citizens for Utility Issues.
So I think it's clear this is impacting everybody.
Absolutely.
We're all sort of in the same boat, and as Rob, I'm glad you brought that up. You sort of beat me to the punch, but we really are appreciative of your leadership here.
Thank you.
Go ahead, Brian.
If I may, I'm sorry to keep interrupting, but I think this is a good point to also mention. We really need to underscore for the public who's following this issue, this is a separate process from the existing law and regulations that we are sort of stuck with right now, even if this other proceeding doesn't change the rules. And so I think we need to make sure people understand we've got this coalition that Gaithersburg is leading the way on, thanks in huge part to Lynn's efforts, but that is to deal with the pending proceeding before the FCC that may potentially make the rules even worse, at least worse in terms of local authority, versus what we've already got and what we talked about at the April 2016 meeting in terms of the laws and the regulations that we have to deal with regardless of what happens with this other proceeding. So I think folks sort of need to separate those two issues in their mind. They're very closely related, but we need to be careful not to conflate them so people think that our involvement in commenting and responding to the pending proceeding at the FCC is not the same thing as addressing the existing statutes and regulations.
Thank you for clarifying.
Absolutely. I did also want to mention, outside of the coalition, we have reached out to MML, in which Ryan is on their board, and the Maryland Municipal League will be submitting a letter in support of our efforts, as well as the Montgomery County delegation of our state delegation. And obviously Kevin Mack is here for Congressman Delaney's office. We have been working closely with him as well. And he's already submitted one letter, and we anticipate other letters coming from Congressman Delaney, as well as Senators Van Hollen, Cardin, and Congressman Raskin. So we've been busy trying to pull people together. The other part of this, and Ryan makes a good point, is this is really focused on the FCC, but we've also used this coalition and the conference calls we've had with all these jurisdictions to share other information and best practices as to what their contact with the industry has been. We are sharing resources on rights of entry agreements, on zoning ordinance requirements, and have also talked about sharing of some costs and developing some more standardized template documents. So that's will be part of the process as well. But I would like to again turn it over to Joe a little bit to talk about the FCC action and what the proposed filings might look like.
Should we go to the
Maybe the next one.
next slide?
Sure.
Is that-
Oops.
Yeah, that might be good to have up.
Okay.
So, this is a very serious proceeding. I think the point you made that we have to proceed as a community, and all the communities have to proceed as they're beginning to deal with the deployment of these small cells throughout their communities. We have to proceed. We can't just wait for the FCC to act. We don't know when they'll act or if they'll act, and our challenge is to come up with a plan that makes sense. In fact, ideally, one of the things we hope to be able to explain to the FCC is that this might not be a time for more federal rules. This is the consequences. The story that's being told by the industry is that if you just get localities out of the way, there will be hundreds of thousands of new jobs and thousands of and millions of dollars of new revenues created because there will be wireless everywhere. The story we plan to tell will be slightly different, which is, to a large degree, these wireless facilities are being focused in areas that do already have some substantial service, and they're being placed in a way where they have potential impacts on communities, not just in terms of the aesthetics, but you have one provider, for example, that's proposing 120-foot towers in the rights-of-way in residential areas. You saw a picture of one of those actually in Baltimore. That was one of their facilities that was put in a place that actually blocked ADA access to a sidewalk. So it's not a question of just creating jobs. We're all happy to have jobs created through deployment of wireless wisely, but what we want to convey to the FCC is we don't need a set of federal rules. We need time to work out those solutions with the industry in a way that avoids the sort of problems we are actually seeing in many places. And for community members, I think it's not enough for the communities and elected officials to weigh in. It's important that they weigh in, but it's also important that the public weigh in. And I think that's one of the reasons we have this slide that shows that there's a simple process for what folks to weigh in on this process by submitting comments to the FCC. It can be done electronically from a computer. And for any citizens group that's concerned about these issues in their community, one place you have to play is at the FCC, because the FCC could eliminate a lot of local authority to actually manage the rights of way in a sensible way. So I think it's really important for them to play. There's also another issue that will not be considering as we go through this process, that localities can fairly raise that community members can fairly raise with the FCC. As you know, and as Lynn pointed out, we can't make decisions about placement based on RF radiation. But I've been around the country enough to know that there are legitimate concerns raised by people in the community about the FCC's failure to update rules that it is required to update, that it's supposed to update on a timely basis, but hasn't done so for years. It seems to me that in addition to expressing concerns about deployment, this is a fair forum to say to the FCC, you could help smooth things out if you would just update your rules on RF radiation, so we would have some set of standards that would help guide us in deployment and in letting these facilities roll out in a sensible way. So again, there's an opportunity here. It's an open proceeding. There's not a lot of requirements to file electronically. It's actually fairly easy, and you can do it with the pretty much with the information that's shown here.
So could I, let me ask a question about the rulemaking. So, we've already heard about the new administration's effort to reduce regulation and whatever you want to call it, regulatory reform. For every new regulation, you have to get rid of 2, and the impact on rulemaking, especially rules that were put in place in the last 6 months, that basically those are going to be withdrawn, I suppose. If this rulemaking is withdrawn, what's the status then of this whole issue?
We just have the rules that are
We
in
have the
place
rules
right
that-
now.
So, and then what does that allow a provider or the service provider, what does it allow them to do with within the current rules?
That protects the service provider against a prohibition or an effective prohibition of providing services, and it ensures that the process the locality goes through will be an open process that's made based on a record and not based on simply a not in my backyard approach. So the existing rules actually cover them pretty well and give time limits for actions. We don't know what it will happen as a result of this proceeding. We do know that some of the commissioners have expressed hostility to local review of wireless siting. But if you were to apply the principles that applied in that executive order, which, by the way, doesn't apply to the FCC, that executive
Okay.
order.
And the commission.
But if you were to apply that same principle, then I think what the FCC would have to do in this proceeding is, at the very least, consider the potential economic impact of the placement of some of these large facilities in front of residential areas. And that may be something they can be encouraged to do.
Joe, can I ask a quick question about the rulemaking procedures on the RF exposure you just mentioned? I'll note that Congressman Delaney, in his letter to the FCC chairman, asks for an update and, I guess, moving along of that procedure, but I don't know enough about it to know what that rulemaking procedure entails. Are you?
I do know, but you're going to run into the sort of limits of my memory as to when
Okay.
they actually
We can talk
start the
offline
proceeding.
about it then.
But they actually did commence a proceeding several years ago where they began to where they were doing a 3-stage revamp of their rules on RF exposure to begin to deal with the fact that I think is recognized that with so many RF devices everywhere, you have to begin to look at cumulative impacts from multiple sources and figure out how to measure those, right? And then they were going to go through that process and then revamp the rules for maximum exposures. So where they've been going through is that first part of trying to figure out how to do the measurements, but we haven't even gotten to the second part of revamping the standards for RF. And that's what's putting us behind, and there's no deadline for action on that.
Ryan.
Yeah, I was going to make a couple of points, but Joe beat me to the punch on the issue of the FCC being affected by the new administration's position on rulemaking because they're an independent commission. So I think
Except that the executive branch appoints those commissioners.
the executive branch appoints them, but I think that still wouldn't affect, once those people are appointed, their own independent authority to proceed with rulemaking. And then Rob beat me to the punch on the other comment that I was going to make, which was that Congressman Delaney's letter does exactly what Joe suggested, which is to address the RF issue to the FCC instead of addressing it to local government where we're not supposed to be considering it. So thanks to Congressman Delaney's office for raising that issue to the FCC. And then finally, there are actually a number of people from the community who've been very active in this issue, many of whom are in the room tonight, many of whom have already electronically submitted comments to the FCC on its docket on this proceeding. So it's good to know they're already doing that. For those who haven't yet and want to, Joe talked about the pretty easy process of going online on the website that's up on the screen. But in order to find the right proceeding, you need the proceeding number. So I just wanted to say for the record that the proceeding number is 16-421 for anybody who wants to hop on that website and make a comment about the proceeding. Again, it's 16-421.
Well done. All right.
And we'll make sure our website is updated to show that as
We
well.
do have the actual proceeding on the website, so that is on the project page under the government tab. You go to the project page.
And I assume there's members of the community that have sample letters that they could share as well.
With each other.
With each other, yeah, not us.
Okay. Joe, were you done or?
Yes, I am.
Okay. Lynn, go ahead.
All right, the next area where staff is exploring at this point is a potential challenge to the Maryland Public Service Commission with regard to the certificates of public convenience and necessity that are issued to it by the providers of these services. And this is another area where we're working with a number of other jurisdictions to further research this possible challenge. You will see that there have been there are similar challenges pending in both
Lynn,
Texas.
can you explain what the significance
Sure.
of these certificates
Sure.
is?
The Public Service Commission issues a certificate of public convenience and necessity, and they have issued that to a number of the providers that have approached us. So they have already gone through that Public Service Commission. There is some question as to whether that gives them authorization to, whether they are a public utility. And there's an argument that they are not a public utility under the definitions that are included in state law, and whether that gives them the right to use the public way. So that's really the issue that we are looking at. There are currently challenges underway in Texas and Pennsylvania, and I know Joe's been very involved in the challenge in Texas. So we're kind of waiting to see a little bit as to what happens in those challenges before we decide whether we would go forward with that.
So this is as we approach how we comply with FCC and federal law.
There's also a state law question here.
Yeah, how do is the state define, we're using this as sort of, we're questioning whether this is, or we're using that certificate as a definition for what a utility is, and we're questioning whether these type of providers are utilities.
Correct.
Okay.
And just as proof that Neil is watching, he just texted me to let he lost the stream. Is there an issue? He's not able to watch us anymore, and that's unfortunate.
Okay, he'll have to catch the replay, or we'll
That's
catch up with Neil later.
That's
Go ahead, Lynn.
So one of the other issues we wanted to talk about this evening is the right of entry agreement. As you are aware, we had an earlier draft of agreement. Staff has been working on that, but we had some kind of key issues that we needed to have some discussion and feedback on before we can get a final agreement prepared. One of the issues is regarding undergrounding of facilities, and certainly we have a number of newer neighborhoods in Gaithersburg where the current utilities are undergrounded. So there's really an issue that where if the utilities are undergrounded, then shouldn't these facilities also be undergrounded? And we knew that, we do know that creates some difficulties. So that was one of the issues that we wanted some guidance on for the agreement. The other is the proof of necessity for use of the right-of-way. This really goes down to kind of a procedure or process question. For a lot of these regulations, we have kind of two ways that we can go about the regulations. We can have a very detailed right of entry agreement and regulations, or we can have zoning ordinance provisions. Which approach we take really kind of depends on kind of the level of public process that you want involving for review of every single application. If we provide more of our regulations through the right of entry agreement and regulations, then it's a fairly straightforward application process once we have those regulations in place. An application would come in, it would be reviewed, does it meet these requirements or does it not? Whereas if we if we focus more on zoning ordinance requirements, those do require more of a public process. There would be a procedure most likely before either the Planning Commission or the Board of Appeals for those to go through. So that would be a much lengthier process to go through. So these are some of the issues that staff
And that
is.
could run up against the shot clock if we were to go through. I'm asking that as a
we
question.
would have to structure it in a way so that it did not run up against the shot clock. I mean, we would definitely have to look at that.
Okay.
We are also looking at stealth deployments and concealments to the extent we want to regulate those. And then there's a question of new structures in the right-of-way. You know, certainly if there's a co-location is different than a new structure. So those are some of the issues. And again, I'll turn it over to Joe if he wants to add some more detail on those points.
These are very difficult questions. I think the easiest one is as I think about it, is the requiring the undergrounding of facilities in areas with underground utilities, because with some exceptions, you're going to be able to find some location off the right of way, maybe inside a building, maybe on a fire station or someplace like that can provide some services. So it will require some clever work on your half, but if the basic principle is you don't get to go underground unless there's no other, above ground in an underground area unless there's no other alternative. Because remember, we can't effectively prohibit. That would be one principle we could build into the right-of-way use agreement. On the proof of necessity versus private property, you may find that you want an approach that balances those two, because there may be some places where placement in the right-of-way makes sense, and other places, particularly residential areas, that are more sensitive, just because the placement, given your setbacks, will involve placement in front of homes. So you could imagine a right-of-way use agreement that authorizes use of some designs in some areas that involves a fairly simple process, but attaches more rigorous requirements in other areas.
I think one of the other key elements that we have to keep in mind is historically we've dealt with it at the right of entry agreement. So if we went to the zoning model, that would apply to other utilities who would also use the right of way. So it's not just going to apply to those utilities that would be small cell providers, but any other utility would have to comply with a similar type regulation. We have not done that historically in Gaithersburg. Other communities have, but we have not.
As far as a new install or as a
New
modification?
install. We wouldn't be retroactive, but it would be any new install. So if a cable provider wasn't providing service to a particular area at this point in time, and we adopted regulations that required utility providers to go through a zoning process, they would have to go through that same zoning process. We could not exempt them out. We can't treat utility providers unequally. They have to be treated in the exact same fashion.
What about with respect to above ground, below ground? Because I can imagine, if the cables are already underground, it'll have a lot less impact.
All utilities typically have some above ground unit. Even the cable providers will have above ground units, so they would still have to go through some process for the above ground unit depending on the qualifications. If we would say it's a certain side, you might be exempt, but if it's above a certain size, you would have to go through that process. And so a lot of the hubs are of a sufficient size that I'm not sure we could exempt them out and then say the other providers for the small cells could be, exempt. You can't have one way or the other. What I'm saying is most of them have facilities above ground. It's not just all underground.
Can you give me an example?
So for instance, you'll see the little pedestal boxes that you have for your
Transformer
providers.
or
So
big
that's
box.
really a connection point for a residential block, but you'll also have hubs that are really 6 feet by 4 feet, usually in a white encased box, that serve as the hub for an entire district area, not just a neighborhood. And those probably are a sufficient size that they're gonna get caught between regulating a wireless provider under the small cells, because they're gonna be larger than what you would normally want to see approved.
Okay. I mean, for my druthers, I would want to have input on that as well. But particularly with respect to these types of facilities that are potentially going in people's front yards, at least the person whose front yard it's going in should have a say, as well as those surrounding neighborhoods.
Well, some of those, above those, where, well, like in my neighborhood, where the utilities are undergrounded, but there are junction boxes or tubs or whatever, they are already there for the most part. So I think the question is, to what extent in a new installation, how big that structure,
Well,
and
look-
whether we can do anything about that.
Let me ask, based on, one of the points you guys brought up is number 2, proof of, if we were to go with requiring undergrounding of facilities in areas with underground utilities, but in cases where it would effectively provide or prohibit service, we would require proof of necessity for above ground. Would that be? Would we structure that to be a public process, where the proof of necessity came into being, or no?
Yeah, I mean, I think one of the things we want to take a look at is the proof of necessity and what level that we want that to, be. Part of the issue is, certainly a provider would, I'm assuming, provide us with some, engineering study, drawings, et cetera, because we've seen some of those in the past. Staff really doesn't have the internal expertise to review those and to potentially refute them. So we would, at least in my opinion, be looking at implementing some type of fee structure where we would have an outside consultant on board, and that the provider would have to pay the cost for review of those types of applications. Because again, we don't want to just kind of rubber stamp anything that they submit. We want there to be a meaningful review of those. So that's one of the issues with the proof of necessity. But I'm not sure that was really your
Yeah,
question.
I mean,
so
I guess
digressed
here's
a
what
little
I'm
bit.
getting at,
Yeah.
Lynn. I disagree with Rob in this sense. I think what I'd like to see us come out of this with is a set of standards that works so well that we can have, that when applications do arise, they can be done by staff, and we don't have to have public hearings every time something like this arises. I want the regulations to automatically protect the neighborhoods by default, and in cases where there's a neighborhood with underground utilities and someone's asking for something above ground, that there'd be adequate notice and protection of the public so they'd be able to have input, and we can address the matter at that point. But I don't, in terms of going through a zoning process for every single utility that wants to put a small box above ground, which is done sort of as a matter of course up through the history of Gaithersburg to this point. I don't necessarily want to get into having those hearings. It's going to bog. It really is a matter of doing business. It's going to bog us down, I suspect.
If we were to utilize the right of entry agreements, would that mechanism permit public notice being given, such as the mailings to those who may be affected within a certain foot radius, and allowing the opportunity for public comment?
Yeah, I mean, it could certainly be structured that way. I mean, I think it would be a combination of the right of entry agreement with also some regulations. And I mean, the regulations, again, are going to deal with sort of the nitty-gritty details as to how that is implemented. But a public notice could be part of that. Again, we have to ensure that we're not making this so restrictive that it effectively prohibits the installation. So there is that balance there. So in neighborhoods with underground facilities, we do have to at least have some process that, again, if they can show the necessity of use, that we're not effectively prohibiting service in those areas.
And
I think the difference between the right-of-way doing something like that, so you have the notification, which is one thing, which is telling people it is going to go here. Then the next question is, do you want a process that says they can provide comment about where it goes and what it looks like? The next, under the right-of-way agreement, the difficulty is we would have to establish who would review that. Would that be the council? Would that be staff? How are you using the data you're getting back or the comments you're getting back to make your decision? With the, zoning model, those are already established. That's the Planning Commission or the Board of Adjustments that would hear those cases and make a determination. So I think we would need further guidance on how you would like it if you wanted in the right-of-way agreement. Because who decides to take that information and take it into consideration, and what input is that?
I think the other thing that's important to keep in mind is a right-of-way use agreement is a contract. So once you enter into that contract, you're bound by the contract for its term. The zoning regulation is a police power regulation, so you could change it at any time, and it would apply going forward. So there is sort of that's another balance. I think in some ways, the right-of-way use agreements work very well for a set of rules that anybody can apply. They're not, a contract is not a great place to set out a procedure for doing essentially zoning in another forum, effectively.
Now, the right of entry agreements, those apply to utilities only, or could we allow non-utilities to operate in the rights of way? Because there is that question that was on the prior slide of whether or not we want to challenge or inquire as to whether these companies in fact are utilities.
Right. And really, I mean, the right of entry agreement is up to us to determine, you know, who that applies to, whether they be utilities or others.
So we could permit non-utilities via
Right.
that mechanism to
Right.
operate in the right of way.
I don't believe we've done that yet,
Yeah.
but everyone who's in the right-of-way is typically a utility.
So when does a requirement, become prohibition? I mean, there's a balance here. It's like it's balancing on a razor's edge. I think when we think about these things, a design requirement, a technical requirement, when does that effectively become a prohibition? So that's, and after you answer that, I've got another question about.
Well, that's a hard one to answer. I think it's easy to answer in the abstract, because when we're sitting in a room talking about it, you can come up with a set of standards where everybody in this room would say, in this city, that means nobody can place an antenna anywhere. So a good example would be, you can only put it in places where sidewalks are 16 feet wide. Well, there are no sidewalks that are 16 feet wide, so that means you can't put it anywhere. So that's the easy.
Yeah.
That's the easy ones. You can define, our goal is to come up with a set of standards that allow for deployment in most, that would provide adequate opportunities for coverage of this area without guaranteeing that everybody has to have service. Because the law doesn't require it. Fourth Circuit doesn't say you get the service, you get to provide the service you want to every household in every spot in this community. It basically says, now we're looking to see whether your rules amount to a general prohibition of service, and if you give enough latitude, then that should be sufficient to satisfy the Fourth Circuit. So that's our goal, to come up with enough latitude to make service a reality. And in fact, the fact is, people in this community will want good service. They don't want bad service. They don't
That's a
want.
good question.
But you want the requirement hang on a second.
Yeah.
You want the requirement both to provide opportunity for the vendor and to protect the residents or property owners as well.
Correct.
So you can optimize the service that they may choose to participate in or not, and to optimize the aesthetic if that's possible. So, so now I'm going to ask the second question I had that's a little bit related, but it kind of goes back to what Neil Harris's note was, concerns about the rapidly changing technology associated with cellular service and broadband and access to the internet. And that is, can you have a requirement that if the devices become obsolete, that they have to be removed, whether they're in the right of way or anything else? If, once they're erected and they are in disuse or not used any longer, can there be a requirement that those facilities be removed and that the right of way or whatever property be restored to its original state?
Yeah. Well, I think Lynn and I have now looked at lots of agreements that have been imposed in lots of places,
Yeah.
and I would guess that every agreement has that provision in it, that if these are no longer being used, they have to be removed.
How often is that enforced?
Well, the interesting thing is, and you know this from using your own cell phone,
Right.
you have 4G LTE that shows up as a bar. There'll be times when you get something that says I'm getting a 1X, and there'll be times when you have no data service at all. You just
Right.
have telephone service. You're going through a series of old and new antennas from which you're getting service.
Right.
What the industry, I think, would say is the fact that we have 5G doesn't mean we won't need the 4G. It'll be a supplementary service, not a replacement service. People will continue to use existing antennas. So there's very few cases where it's happened. Unfortunately, and this is something we should think about in the right-of-way use agreement, the places where it has happened, it's because the company that built the facility went out of business. And then you're in a bankruptcy situation, and the company may not have the resources to remove the facilities once they're on the poles. So one of the things we need to think about is, in a situation where you have a distinction between the providers, who are probably not going to go out of business, they're going to be either acquired or they may merge, but you're not going to get a lot of frequencies that are unused in the United States, and the companies that are providing the facilities. And you want to make sure that you have enough protection in the right-of-way use agreement so that if the providers decide they want to use a different technology, you have some way to make sure the facilities come off the poles and things are cleaned up.
Can you give examples? Like, can we require bonding?
A
of it?
bond would be a
Yeah.
perfect example, or a letter of credit.
So again, a requirement that's not necessarily a prohibition, but a condition that may make the business decision a poor one.
Given the price of
Don't
letter
use
of
the
credit,
phrase
I
a
doubt
poor
it would
one.
affect. I doubt it would
Oh, yeah.
affect them.
Well, it's
But
called protecting our interests.
It's,
We-
well, it's
they can-
protecting
Yeah.
everybody's interest, but so I'm getting back to this issue of when does a requirement become a prohibition? So you can require things at the front end, you can require things at the back end, and just the way technology changes, it doesn't make sense not to consider outmoded facilities, obsolete facilities, or inoperable facilities that should be removed if they're not going to be used.
Mm.
So,
Do we know if that point was made in the FCC, in our comments to the FCC? Because that's one of the positions that Mobilite is making, is that local jurisdictions are placing onerous fees onto them, making it so it's more difficult for them to operate well. On the flip side of that, local jurisdictions have an interest in protecting the properties, such that if these guys do go out of business, somebody's gonna have to remove it, and if it's not them, it's gonna be us or the property owner.
Yeah. Well, the comments at the FCC have not yet been submitted.
Okay.
So they are not in the current comments, but I'm sure Joe will take a note of that and
Thank you.
include that in his filing.
And then, could I just circle back on Mike's question, because I'm not quite clear here, and I'll give an example. Say you've got an area that's serviced by the four, Verizon, Sprint, AT&T, and T-Mobile, although T-Mobile might be shaky. And you've got Crown Castle who wants to come in, and they're providing Verizon and Sprint. Can we deny that application because the four are already operating there, or are we effectively prohibiting the service by telling Crown, you can't come in here and provide Verizon and Sprint? And that is back to my original point, is are we talking about the service coverage, or are we talking about the prohibition as to the entity? Because I think that's where the FCC's new rulemaking kind of blurs the line, because they talk about it, it seems, in the context of the entity, which could be dangerous, because then if we then say to Mobilite, well, Crown Castle's got a pole right there, you can't come in.
Well,
And you see-
what the law says is I can't prohibit or effectively prohibit anyone from providing wireless services. But what Crown Castle and Mobility, they've all said very clearly when they apply, they aren't providing any wireless services. That's their position, right? They provide a facility and then a line or a connection that goes back to a central location. The service they provide is carriage from antenna A back to a central point where they can connect to the public switch telephone network. That's the service they claim they're providing, not a wireless service. So if there's adequate wireless service in an area, you can deny an application if someone can't, if you are dealing with the question of, do you actually need this facility? I will say that I haven't seen many cases where companies actually get asked by a Verizon, who has to pay them money to use their facility, to put something in where a Verizon doesn't see a need for the facility, right? They aren't overbuilding just for the sake of overbuilding. They're typically putting in facilities because they think they either are predicting a shortage based on capacity usage, or they actually see a shortage at particular times.
I think it's really important that you distinguish between service and capacity, because most of the providers will talk about they already have service in these coverage areas, but they need capacity. And so I think the regulation talks almost as much about service as it does capacity. They would view that as a need that they need to fulfill. So it would be somewhat difficult to determine without really expert advice that they aren't meeting their capacity issue. Because we could probably prove that they have a service area that is covered, but this is really about capacity, not service area. You know, they just can't get enough data through the existing facilities to cover the capacity that's being demanded of them by your 3 iPads at your house and your 2 phones and all of that.
But I think this is the conversation we had back in April of last year when we were just trying to get the underpinnings of the law. And my understanding is that the law underlying the regulation talks about it in terms of service, not capacity. So you don't, service providers don't get to come in and say, we simply don't have enough, we want more. You can't prohibit us from providing more. But
I do believe that's their argument, because most of them, they're not covering gaps in service. There might be a few cases they're covering gaps in service that you don't get a signal. You know, you get no bars. They're talking about capacity issues, and 5G is about capacity issues. So they are looking to increase capacity, not just cover the no service gap. Because my guess is if you went to the areas that they're looking at, they probably have fairly decent service coverage. You'll get 3 bars or 4 bars in these locations. They just can't handle the data load that it takes when everyone's on their different device.
All right, so
Yeah.
I sort of want to steer us back onto the rails here. Lynn, we were at the slide for the 4 points on right of entry
Yes.
agreement. Do you want guidance now, or do you want to go through the rest of the
But I
presentation?
think I'd like to go through the rest of the presentation and also obviously listen to the public comments, and
Yes.
then kind of we'll loop back around to some of these issues.
Okay,
So,
good.
We just had a couple of slides showing some on the concealment, some different ideas of rooftop concealments. A lot of these pictures are like Frederick, Baltimore. This is one where it shows the chimney concealment option. And the text amendment, and I'll run through a lot of these slides very quickly because this really just goes through our existing ordinances. We did update in 2015 our ordinances, but it dealt with our regulations for these types of facilities on private property, and did not really address the public right-of-way issues.
But it is about stealth and unobtrusive.
Yes, yes. So certainly, if a property owner wanted one on its private property, we felt that it was important to also have some regulations there to limit and to deal with some of the stealth issues and the safety issues involved. We did also adopt regulations dealing with public property. Again, this is not the right-of-way, but for other public property. And certainly these are some of the scenarios where companies have come to the city for towers on its property and the process that we've used for those types of proceedings. We do have an existing provision of the city code that talks about utility regulation, which does talk about a Board of Appeals process. I will tell you that this has been, from our planning staff's perspective, they really can't cite a occasion where this has been used for the public rights of way. This has been used, for example, for transformer areas and other larger facilities that were on public property, or on private property for those larger facilities. But this would be one area that if we were looking to make changes into our zoning regulations, we would take a look at Certainly, we would want to better define public utilities in this section. And this is clearly outdated language. And again, there is a question of these types of facilities, whether they would meet a definition of a public utility. So again, when we're looking at some of the zoning regulations, if we want to take a look on those types of regulations, these are some of the existing regulations that we adopted in 2015. So as we're looking to go forward, there are a question, and again, this kind of goes back to the process question we had some discussion on earlier, is if we wanted to include these, the small cell facilities in the public right-of-way under 24-162, that would put it into a special exception process, which would be a proceeding before the Board of Appeals, and we would have to include criteria as to what would be adequate safeguards for adjoining properties. Certainly the other options would be to expand the existing 24-167 of the zoning ordinance to include a section on the public right-of-way. Some of the types of criteria we could include, we have listed here about as far as setback from structures. That would really kind of be the whole issue of the fall area of a potential pole. Restrictions as to how close the poles could be to one another, and we could provide, additional requirements for stealth design there. Again, we've run through some other criteria that could be included in that type of language. Again, if we put this in this section, then it would become a planning commission process, so that each one of these applications, if it will come under this regulation, would go through the planning commission for process. But it could include height limitations, requiring a place, if it replaced an existing pole, what the process for that would be, restrict the number in a right-of-way. Again, with a lot of these regulations, if this is the way you want to go, we need to be kind of very careful as to how we craft these to ensure that we're not effectively prohibiting the facilities in the right-of-way. So
Can
we
you explain
want
that last bullet, Lynn?
the create clear safe harbors.
Yeah.
That's really the point that we can't effectively prohibit. So we would have to craft these in such a way that as they are applied, it would still allow these facilities in areas where there was a clear showing of the need.
As long as the community is not harmed.
Yeah, again, that's that whole balance issue of, how we balance those two requirements.
Okay.
Then the existing 167E, in a couple of slides back, talked about one of the existing requirements being proof of licensed provider or public utility in compliance with the laws. So, it gets back to the question of definitions and what is a public utility in this debate. Obviously, entities like Crown Castle and Mobility are not licensed providers.
Right.
They don't provide the service. And then there's the other question of whether they're public utilities. So under the existing definition, there are questions about whether or not they would meet those requirements.
Yeah, and that's another reason why we are exploring the option with the Maryland Public Service Commission to get some clarity around that particular issue. Because, the PSC does issue those certificates to these types of companies. They've submitted them to us. We've seen them. But again, we're not exactly sure of how those apply in the situation. Certainly another option under our existing ordinances, while we have, when we amended the ordinances in 2015, we did allow these uses on private property, but we could further expand that to allow additional uses, particularly in residential property, but we'd want to be very careful to ensure that there was that stealth component there. And again, some of the examples we showed with some of the chimney installations and those types of things, if we could be more flexible as to what we allowed on private property, again, assuming that those stealth components were met as well.
As a matter of practice, and this may be a question for Joe, we saw the picture that showed, the
chimney?
concealed facility on a single-family residential property. Where was that from? Virginia, you said?
The one that kind of showed the big white kind of Victorian house, that one was in Virginia.
Okay.
Some of the ones that were on the brick facilities, one was in Baltimore and one was in Frederick.
Okay, so my question was basically just, how is this done? How often is this done? Where is it done when we're talking about putting concealed facilities on single-family residential?
I'm not sure how often it's actually done through most zoning codes, because I think in most cases, I'd say the normal would be, it's not done that way.
Mhm.
But, and I'm not even sure the facility you showed was a single-family home versus
Yeah, I think the one was the two brick facilities, those
Right.
are more commercial structures, again, both in the downtown Frederick
Yeah.
and downtown
Right.
Baltimore areas.
but I will say that right now, if you went online, if you had bad cell phone service in your house and you'd go online, you could buy a femtocell from Best Buy that would allow you to boost, which is essentially a small cell antenna. It falls into the class of, quote, small cells, technically. So it's not inconsistent with actually what people are doing right now. People are already using small cells in their home. They just don't know that that's what they're using.
Well, the nice thing about that is you can hide that on your desk.
You can hide it on your
You don't
desk.
even have to hide it, it's on your desk, and none of your neighbors knows it's there.
Right, right. And
Until they
actually,
see
and
the
actually it'd be
sig-
fairly, and I think the thing about expanding it is if you do it carefully, you might actually have an installation that's designed to serve more from a residential property that would be a lot less obvious than some of the other options. Whether you'd find a homeowner who would be interested in doing that is a different question, obviously.
Right.
Yeah.
Yeah, but in that case, again, it would be up to the homeowner, it wouldn't be kind of forced upon them. So, kind of our last slide deals with next steps. Certainly, we will be submitting comments in the FCC action by the March 8th deadline, and we'll continue to explore the Public Service Commission challenge and report back to the mayor and council on that issue. We provided some tentative dates for producing the right of entry agreement. We do think it's very important here that we have a draft, and then we've included a 1-month period of time where we could circulate this both to the industry as well as our residents, so that there would be adequate time to comment before that would come back to mayor and council. I want to kind of leave some of these dates on hold till after we hear from the public, and also once we get some feedback from the mayor and council, because again, depending on how significant changes are or expectations are, some of these may have to move a little bit. But.
So, yeah, so if we wanted to change the conditions in 24-167, AE, whatever it is, would we have to do that before we finish the right of entry agreement?
No. I think that these processes can run concurrently, because certainly.
One is dealing with private property, the other's dealing with the right of way.
Well, the ones that are dealing with the
Well,
right of way. So-
there are both.
They're both.
But, as you all are certainly aware, that with ordinances, particularly when we're dealing with Chapter 24, it's a rather lengthy process, because there's introduction or sponsorship. It's got to go to the Planning Commission. There's a joint public hearing. It comes to you all for final action. So, that's a process that generally takes anywhere between 4 and 5 months. So, I think we can start that process and be working on that at the same time that we're working on the right of entry agreement.
So, I guess I'm concerned about finalizing our right of entry agreement and how quickly we'll have an application, or the potential for an application that basically starts the shot clock, and whether we can get the other things done that we need to get done. I'm interested in this PSC challenge and what the likelihood is that we could prevail on that. That seems to me logical, but we don't do those regulations, so I don't know. But it seems like the most logical challenge to these companies. I don't see them as I don't see them as utility. I don't think I didn't have anybody argue with me up here, but that's my opinion.
Before we get into questions and some back and forth, I want to thank you guys for the presentation and for a tremendous amount of work that's gone into getting us to where we are. When we had this meeting last spring, we certainly did not have the grasp of of our legal authority, and we still don't fully, but we have much deeper grasp of it, and I appreciate that. And I know that there's a lot of people here from the public who'd like to weigh in, and I'd like to give them a chance. But before we sort of opine, if we have questions about the presentation, or Ryan, if you wanted to comment on Mike's, and then we can go to the public.
Yeah, I mean, I just wanted to respond to what Mike said. I mean, I think he's right, and that we've been very, very fortunate that we haven't had an actual live application in the city thus far to deal with these shot clock issues. But it seems to me that unlike text amendment process, which, as Lynn pointed out, takes a certain amount of time because by law we have to have notice and hearings and all that sort of stuff. If an urgent situation arose where we had to quickly finalize the right of entry agreement more quickly than this schedule proposes, I would imagine it could still be done if we absolutely had to against a shot clock, but hopefully that is just a hypothetical. I did also want to mention, as for your next steps, number one, I think you mentioned earlier when you were talking about your coalition that the Maryland Municipal League agreed to submit comments to the FCC as well, representing all 157 municipalities in the state. And actually just this week, the National League of Cities also submitted comments to the FCC on behalf of all municipalities around the country, expressing significant concerns about the FCC pending proceedings. So I did just want to flag that as well, so folks know that that's happening. And I'll have some other questions, I think, later.
Just 3 issues I didn't see in the presentation, and I just perhaps would like some information on. One is with respect to the cell facilities that have been going up in various easements, I think in the Petco easements or Exelon easements around the city. I've noticed at least 3 that have been installed. Which of the processes, if any, would allow us to have some modicum control over those installations? Second question is with respect to other wireless facilities. Like I've heard that, for example, some of the cable providers have been putting wireless facilities on their lines. I'd like to look into details about that and details about whether or not we could, to what extent, control those processes as well. And then the third issue that I didn't see covered here, and it might govern next steps, or it might not, is I couldn't find a status on the county's ZTA 1605, which was their zoning text amendment pertaining to the installation of small cell facilities in their rights of way. Do we know where that stands right now? I know they had the public information session over at is it Ridgeview, the school just off of Quince Orchard Road, and then that's the last I heard of their process. Do we have an update on that?
Yeah, my understanding is that has been put on hold, but I will certainly double check to see if they have anything further scheduled.
Anything else?
Yeah, I mean, if you can just follow up with me later on those.
Yeah,
other 2.
we're not aware of any movement on that. So I don't think they've actually done much unless they've been doing it internally.
Right.
I just wanted to ask a follow-up question about the process for finalizing a right of entry agreement. Once the process sort of comes to the culmination and there's a draft or near final draft that's gotten the input of stakeholders and presented to the council, is the idea, Lynn, that the council will approve a template right of entry agreement for future use, but then we'll also individually vote on the approval of every future right of entry agreement? In other words, it's not like we're taking one vote and then staff will enter into this agreement in the future with applicants. It's that the vote is for the template, but as applicants individually come forward asking for a right of entry agreement, once staff works with them and determines that that's appropriate, they will again present it to the mayor and council for a final vote on each individual right of entry agreement before it is executed.
That is correct.
Okay.
Okay, let's go to the public. So this time, the mayor and council would love to hear from anybody in the public who'd like to speak. We ask that you keep your comments to 3 minutes. When you're down to 30 seconds, the timer will beep and turn yellow. When your time's up, it'll beep and turn red. And we ask that you state your name and either your address or your neighborhood. Who'd like to be the first speaker? I know there's some speakers out here. I don't mind. Go right ahead.
My name is Aaron Rosenzweig. TeamGaithersburg.org. I live in Wesley with my wife, children, and chickens. Lynn, Frank, and Dennis, thank you. You've made an about face. Come a long way from 10 months ago when you said we had no choice and you'd signed an agreement with Crown Castle. You've put a lot of effort in. I'd like to see the City Council put some more effort in and back them up too. I was the first person to put comments for the Mobility and FCC. You can see them online. Sue Present from Silver Spring did a fabulous job. Everybody should go see what Sue Present did. They're all available there. I want to see each of you do your homework, put your thoughts down, and put a comment out there, like the rest of us have. Some of the things we haven't talked about is that besides a girthy pole or a skinny pole with the cabinet outside, we can put those cabinets completely underground. No humming, no waste of space. Think about putting those cabinets underground, the radio cabinets. Now, I don't like the idea of this single-family residential dwellings having something on top. We need to at least modify our ordinances and say how tall they can go. Right now, we have no limit on the tallness of our chimneys, stealth chimneys that we might have now. I don't really like opening this up. But I want to say this. Ocean City, the mayor over there, my man Meehan, he don't play. 4 months ago, he got out on the radio and in the newspapers, and he said, it's crucial that the public speaks out on this. What they do if we don't speak out is when they go before the Public Service Commission, they just say, well, nobody said anything. So that's why we think it really is crucial for residents to let them know, because you don't want this in your neighborhood. I want to see each of you do that. Get on your Facebook pages, talk to the Washington Post, say, hey, we need the citizens' backup. Sound the alarm. He goes on to say, Crown Castle has already submitted permit applications for as many as 90 of the proposed towers, but this office has rejected each. We told them very strongly we are opposed to these installations, particularly in our residential neighborhoods where utilities are already underground, he said. They have submitted over 90 of these installations and we have not approved a single one of them at the local level. This was back in October, 4 months ago, and today they've signed an agreement with Crown Castle rejecting all deployments in residential places. Only in the outer areas and the boardwalk and stuff where they have them. They've completely rejected in residential areas. We need to do the same. We need to speak strongly and tell people what's going on. We need to send things out in the mail. We send things out in the mail for other reasons or to get you reelected. You need to let people know that they need if you think chickens is bad, Valentine's Day is around the corner, all right? Nothing says I love you like a 30-foot erection on your front lawn. Thank you.
Do we have any other speakers this evening? Please come on up. And anybody who else who would like to speak, please line up behind this gentleman.
My name is Stephen Rayfield. I live in Wesley. And I just wanted to touch base on a couple of comments that were made during this discussion. One of the slides showed that there was an ordinance that had a minimum height. I think that should have been a maximum height. Or if we have an ordinance that says you can't build anything shorter than a certain amount, that doesn't seem right. You may want to look at your slide on that. Another comment that was made was that you could buy these kind of cell towers, transmitters at commercial stores, Best Buy or whatever. they aren't the same. Okay, the ones that you can buy for personal use have a maximum power output of 300 milliwatts or less, and they're unlicensed. The ones that are being proposed to be put in our neighborhood are more than a kilowatt. That's the equivalent of having a microwave oven with no shielding sitting on your front lawn. So they're very, very different. 300 milliwatts is a lot different. I mean, it's the difference between a major generator and a cell, a D-cell battery. So we're not talking about the same thing at all here. And the ones that you can buy at Radio Shack are maybe $100, $200. They're not talking about $200 installations here at all. They're totally different. They don't even run at the same frequencies, but that doesn't matter. One of the other issues that we raised back in April that wasn't addressed here at all is the consequential and subsequential damages to the property value of the homeowners that now have a 30-foot high post sitting out in front of their house. Who's going to pay for that? Who's going to compensate the homeowners? Is it going to be the county? Are you going to, or the city government? Are you going to take it out of the income from the existence of the tower? Or are you just going to say, tough luck, go home, the government has decided your fate? We've had estimates from experts that it could impact property values by as much as 30%. So we're talking about some pretty serious concerns here. The idea of producing a shortage of data rights, I don't know if you saw the newspapers today, but T-Mobile announced that they're going to offer unlimited data services again because they have so much excess capacity, and they're the smallest of the providers. Verizon responded by saying, we will too. So there is no capacity shortage. This is nationwide.
Steve, you're welcome to provide the rest of your comments in writing to us, and we'll consider them. Thank you.
Thank you.
Do we have any other speakers this evening? Come on up.
Good evening, I'm Vasilios McGinnis from the Wesley Development. I wouldn't agree more with the statement that Mr. Neil Harris made at the beginning of the presentation, but should we flood the city with all these towers? Is that a good idea or a bad idea? I'm with him. And I will disagree more with you, Mayor, that we have a better handling now than we had a year ago. All these things, thankful to the work that Ms. Borg has put together, along with Mr. Esslinger and so many of you in the city, try to address this complicated issue with the cell towers coming to our neighborhoods. I would stay with 2-3 items over again as this affects my community. One is that we have below ground utilities. Since the development was constructed 43, 45 years ago, nothing sticks above ground, and we should stay like this. This is very crucial for us. We have brought this to your attention in several occasions and try to work with you in many items. The other item that I'm going to talk about, although I have brushed this thing, is right of way. Somehow we should have limitations. We start talking about right of way agreement, right of entry agreement, but we never say all the right of way is the same. I look at the zoning code section 19 that has a residential secondary, 50 feet right of way, a residential primary with 60 feet, a residential collector with 70 feet, and then goes to business district with over 100, 120 feet, and many other categories. Just pull up the measure tape and measure my street today with 34 feet pavement from curb to curb. That leaves you 16 feet to go to 50. It's a 50 feet right away. 16 feet divided by 2 in each side, you have 8 feet. What are you going to put in this 8 feet? Current zoning law, section 24, states that any of these facilities should be 3 feet away from the property line. So from 8 subtracting 3, 5 feet left. And then the code comes down to say some of these boxes, the utility boxes that are going to put next to the towers, are 5 feet. This means you have a box sitting next to the car waiting for the next truck to come and strike it. I don't think it's the way to go. Somehow the 50 and 60 right-of-ways have to be taken off consideration. And you have to look at other neighborhoods who can support and have larger right-of-ways. These are some of the things that we have. We will
Thank you very much.
respond to FCC accordingly.
Thank you.
My name is Sheldon Pine. I live at 35 Treeworthy Road in Gaithersburg. I am one of the petition residents of Wesley that you've heard from and will continue to hear from. I wrote each of you earlier to express my deep appreciation for the tremendous amount of work and the quality of work that Lynn and Frank and Dennis have done. This is a very complex issue, both legally and technically, and we've advanced, quantum leaps from where we were a short time ago. One thing that I hope is, as we know, the key documents, that is a draft of a city ordinance and the right of entry or the franchise agreement, we're still working on those, and I would hope that there would be some opportunity for some public input in those prior to the time they're finalized. The petition citizens of Wesley are fortunate in a way. We bring a lot of expertise to bear. Steve is a radio frequency engineer with 30 years of experience. I'm a Yale Law School graduate. I have 30 years of regulatory law experience. And there are lots of more expertise. Just happens to be because Gaithersburg's a great place to live, and we have a lot of people with professional background, and we hope we have some opportunity for input there. I think we've touched upon a critical point tonight, at least from the perspective of our citizens, and Lynn's slide and Frank's slide 18 and 19 talk about that. In a community where by deed, and people knew this and bought this when they bought their homes, where by deed, all public utilities are buried underground. The rule should be that there are no above-ground cell towers in that community. And I think that needs to be in the ordinance. I think in the point that Joe made, there are some things that are, a contract's a contract. And it's hard to do a negotiation in the context. Contracts are designed to be binding and rigid. And you can always adjust and tweak an ordinance if you need to. And I think that ought to be a rule. And I think that ought to be in the ordinance. That's just our perspective as a community. And I think, in addition, there's sort of an investment-backed expectation that people have. Anyway.
You have 30 more seconds.
One last point, I want to slightly differ from something that Lynn said. This issue of when the city's acting in a proprietary capacity, I think clearly if it's a city building, absolutely. But the issue of the public right-of-way and the city's ability to regulate the public right-of-way, the 2015 FCC regulations specifically held that question open and said, not decided yet.
Thank
so
you.
we may be able to work that issue as well.
Thank you very much. Lynn, I want to ask a follow-up based on Mr. Pine's testimony here. You mentioned in next steps about the draft right of entry agreement, and that can you describe again sort of what the public's opportunity will be to provide input on that?
Yeah, I mean, what we are anticipating, and depending on if the dates stay as proposed or if they move, but we would propose at least a 30-day period where once there is a draft of the public right of entry agreement, franchise agreement prepared, that would be available for both the public to comment as well as the industry as well. And then after we would get those comments, we would try to finalize the document for consideration by the mayor and council.
And amendments or revisions to the ordinance, then the same opportunity for the public to comment on that since
Yeah,
we go
those-
through normal process.
Yeah, those would go through the normal
Introduction, work
process.
session,
Yeah, so
everything
there
else.
would be
Right.
adequate opportunity and public hearings
Right.
on those ordinances for the public to be involved in.
Will we be looking to make our right of entry agreement uniform with the other municipalities? I saw some mention of a model
Mhm.
agreement.
Yeah, we've had some discussion of that between the various jurisdictions. There are some jurisdictions who've already adopted their right of entry franchise agreements, and frankly, I don't know that I believe that some of them have gone quite far enough. And then there are also different issues involved in well, depending on each jurisdiction, because different jurisdictions treat their right-of-way differently. Some do regulate it by zoning, some do not. But we have had some discussion of developing kind of a template that jurisdictions could use, with the understanding that each one would have to customize it a certain extent to their individual needs.
Did we have any other speakers tonight?
My name is Bob Mitchell. I live at 13 Turnham Court, and I've lived there since 1975. I was particularly interested in the comments from Neil that the mayor read at the opening of this session, which had to do with taking a much longer-term view of the technologies involved and thinking about whether this is in fact a good investment. I'll have to leave pursuing that to someone else because it's not quite my area. I do read things occasionally, though, on things like 5G, and it seems to me like I have read that 5G is in fact the 5th generation, but we have no idea what it is yet. Some of the details, some of the frequencies, some of the specifications, some of the protocols haven't been decided. Everybody's worrying about it, but they don't know exactly what it is. So we know we're going to have the 5th generation. It'll be the generation that comes after 4, but we don't know a lot about it. One of the questions that I saw raised was whether or not 5G was going to be using an area of frequency that was not regulated at this point, and that it could be the same frequency that's being used by the Wi-Fi in our houses. So I'm wondering if someone could nail down whether or not any of this is going to interfere with our Wi-Fi, because I believe if I have a choice between my Wi-Fi in my house and my 5G coming from the tower, I would much prefer the Wi-Fi in the house. Now, one practical comment. There were some questions about how to take down the towers if the technology was no longer any good. I would think that someone could specify that a hook be put on the tower near the top, and that it be designed so that the city could put a wire on it and attach it to a truck, drive a few feet down the road, and it's designed to snap off right at the surface, and then the homeowner could bring in 2 or 3 bushels of dirt and put over it. So I would think that some thought could be given to that ahead of time. Thank you.
Thank you.
Can I ask a question of our experts, Mr. Mayor?
Please.
So this question of the 5G technology and when it's going to be rolled out and whatnot, it seems clear to me that these companies, Crown, Mobilite, are installing in anticipation of that need in the future. So they're looking to build current capacity for future needs. What, under the regulations, what ability do we have to say, well, 5G is not here yet, it's not going to be here for years, deny your application, come back in 5 years? Is that even something we could do under the current regulatory regime?
Well, from the applications I've seen, that's actually not what's going. I hate to say this, but for those of us who've been around long enough and have been through 4G, do you remember 4G actually is a marketing term, not a real thing, right? 4G is something, there's international standards for 4G, and there will eventually be international or national standards for 5G, right? But that doesn't mean that the companies that have rolled out 4G are actually applying those standards. They're not, right? We rolled out 4G years before the standards actually existed. It was a marketing ploy to get you to buy something new. What you're seeing in 5G is the same sort of marketing ploy. You're going to have companies rolling out something they call 5G that have nothing to do with the standards, which won't be rolling out till 2020. They'll be coming out with that marketing tool anytime they want to come out with it, right? What you are seeing them design to is the technologies they plan to deploy over the next 5 years. So what you're seeing with these DAS systems is an effort by companies to provide coverage inside the home with the goal of providing really high-speed data or much higher speed data than can be currently provided with wireless technologies that exist today. So it really isn't a matter that they're doing this in anticipation that when you give the approval, they're going to put 5G on a pole and it's going to be providing something, a standardized service. They're doing it planning for the service they would provide using the equipment they've got in their truck now. And so you're seeing a rollout now of facilities that are about 500 feet apart that are designed to take, and that's what we're seeing around the country. And they're not planning to deploy a brand new technology. They're deploying the same technologies they've been using for years. So there's a little bit of 5G is really, in some ways, a little bit misleading, and it creates a double-edged sword because I go everywhere and people say they don't need it because there's this new technology that's going to replace everything. That's not what's actually happening. 5G is the way they talk about why they need it, but it's really not why they're planning to do it. They're doing it so they can take their frequencies, use them, and provide higher capacity to end users with their existing equipment.
My understanding of this 5G technology is that the equipment, I believe the maker is Cisco, and it's not even out there yet, and it's set to operate in ultra high frequency bands that aren't currently being utilized. So it is moving to a different area than the current services that are being provided.
It is, but remember what you put on the poles isn't static, right? So in those boxes that you saw the pictures of, you can open those boxes up. You can take out equipment and put in different equipment. So they're actually planning their systems based on what they can do with the equipment they have now, and they're anticipating that will be sufficient for what they anticipate will be rolled out when they move to a new generation of equipment.
So kind of like a placeholder.
Yeah, it's no different than, so when 4G was rolled out, they did do a number of antenna changes through existing poles. They didn't really put up different type poles, the main towers that you have now. Most of the providers went back and swept out their antenna locations in terms of what they actually have on that facility. So they have improved the technology. The question is there really going to be that significant jump between 4G and 5G? I don't know that. And again, the other thing to keep in mind is there are industry standards, but in the US, they're approached in the way that Joe talked about is they're not required to meet the industry standard to roll out technology. Some other countries require you to have the new technology and meet the industry standard, but we have a very open market system that doesn't operate the same if you go to Europe or other locations. Because they're treated more as a utility in the sense that you have one or two main providers who provide cell service throughout the city, and they're all on the same platform. And again, on the US, part of the reason we have 4 providers is there's 2 separate platforms that they each use. 2 use one and 2 use the other, that actually determine what type of technology they use to transmit the signal. So I think Joe's right that we don't know what the 5G means. I do think they're leaning towards 5G and providing in-home service. Does that mean the cell phone providers are looking at trying to roll your home internet service into that? Maybe, we don't know. That's their industry. We don't regulate that component. Currently, most people use their existing cable company to provide their Wi-Fi service provider. I don't know if the cell phone providers are looking at that to say, well, you can, get rid of your cable because we provide that service for you through these DAS systems. I couldn't tell you whether that's really true or not.
Jim.
My name is Jim Rolfus. I live in Wesley also. I also want to share my appreciation for the work that the city and the city staff and the city leadership have done on this issue. Certainly a very different kind of conversation tonight than I think we had that, and thank you. We've talked a lot about the issues about why the proposed approach isn't right for the residents of the community. I want to share a little bit about why I don't think it's really good for Crown Castle either. And this may be outside the ability for the city or even government to affect, but I think that there are economic issues here that I think make it really in Crown Castle's interest or any other small cell provider's interest to really go to the value proposition for the end customers. So when we were here previously, Crown Castle talked about that they were a carrier's carrier. So they saw that their customer really being the Verizon, the AT&T, and that really largely sounded as though they discounted the interests of the citizens, that the placement of these towers, it was because it was technologically optimal for their purposes rather than what really would work best for the people who live in that neighborhood. I think what we've seen and what we see really playing out across the country is that that's not really a very good business model. That even if we aren't the customers of Crown Castle, certainly the carriers certainly do care about the value that we provide to them. That they are interested in potentially leasing these facilities because it will improve our service, the value that we get. Now, I think to some extent Crown Castle may be thinking that because we probably won't give up our cell phones and drive markets that way, that we really have no voice. But there could be other ways that voice is heard. It could be in similar ways that the community developed a petition and brought it here for consideration to express the seriousness. We could also share that same kind of information with the carriers and express to them that the installation of these services do not represent value to us. Now, so if there are I think there were 3 towers in Wesley, about 60 in Gaithersburg, that means that Wesley as a community is maybe about a 5% value to the proposition and their negotiations with these carriers. If the carriers themselves were able to pull out a letter that said 5% of what you're trying to sell me doesn't deliver value to me, I want to see a 5% reduction in your pricing, we may be back in an economic model that gets these providers to participate and care more about what is actually in the interests of the people who ultimately are being served by this. So, thank you.
Thank you. Any other speakers? All right, not seeing any. Lynn, do you want to get to the specific guidance that you need from us this evening? Or do you feel like you have it at this point?
I think that we have enough to kind of move forward with some draft documents. And I want to kind of revisit I think it was on our last slide, was sort of the next step of schedule. Based on the comments that we've heard tonight, we are working on to finalize a right of entry / franchise agreement. One of the issues that came up this morning at our regular agenda meeting is if we wanted to bring that back to work session, the first work session isn't available to May 22nd. Unfortunately, we're like really booked, which I guess is good. But based on that, I would suggest maybe we move some of these dates back. I think it's still very important to have that 1 month comment period, both for our residents as well as the industry. So what I would suggest is that maybe we move back the schedule so that we would have a finalized draft for mayor and council consideration at a work session on May 22nd instead of approval on May 1st, and that we'll adjust the other dates accordingly. And we will certainly submit the proposed schedule. We'll both put it on the website as well as issue a press release so that our residents are aware of when they can expect to see documents, so we can optimize to the extent their participation and input on those documents. I would suggest that we do kind of move forward with the zoning ordinance amendments. I think we would probably still want to, before we go for formal introduction or sponsorship of those, bring a draft for some review, because again, we're trying to sort of balance what we need to put in the right of entry agreement with the zoning ordinance. But again, it makes sense to kind of move the zoning ordinance forward a little bit more quickly than the right of entry agreement.
Okay.
Now, with respect to the right of entry agreement, what happens to the utilities that currently have agreements? And this goes back to my question about Pepco.
Mhm.
They have various easements, and I understand that they operate in the rights of way, that they're installing, looks like cell facilities on their poles, which I'm not sure would fit within the provision of electricity. Can we go back and renegotiate those agreements, or do we have to effectuate zoning?
Well, I think that the question is, we are aware of one installation on a Pepco, in a Pepco easement, but it's not in the public right-of-way, it's an easement, so it's a little bit different issue. I mean, that is actually on our private property, but it is subject to an easement.
What about, so on, there's a few installations that just occurred in the last 2 months on Quince Orchard Road, immediately adjacent to the Diamond swimming pool. And it looks, they're near the high tension wire, so I'm assuming that's the Pepco easement.
It's the county right away, not ours.
Yeah,
probably.
yes, I was gonna say, I mean, there are some
Because it's by
facilities that
120.
have been erected in county right-of-way. There's some on Muddy Branch and some other areas. So, I mean, that's a little bit different issue, and I think that was one of the questions you asked, is our ability to control installations on either county or state rights-of-way that are located within the city.
And the answer is not very much.
Not very much, unfortunately.
Well, as far as the Pepco easements, the one we talked about is on our crossing our
Yes.
property. Are there other easements held by Pepco that cross other colors of property, whether it be private or?
I mean, Pepco holds a lot of easements,
Okay.
a lot of easements.
Well, I had some in the county right away too.
Yeah.
Mhm.
Easement, so, you know, that's, again.
So
no-
my point
Yeah, and I
is
mean, I
just to the
think that the
extent.
issue, I mean, the one that is on the city property within the Pepco easement is a completely different issue, because certainly that easement only authorizes electric power facilities to support electric power, and this clearly is not. So, I mean, I think that is a different enforcement process.
I mean, just to the extent possible, I think we should know what's going on in our city and effectuate our ability to at least have the option of control over what we can. So I understand if it's in a county right-of-way, we don't exercise control. If it's in a state right-of-way, we don't exercise control. But to the extent there are different opportunities that wouldn't be covered by the right of entry agreement that might need, for example, modifications to the zoning ordinances, I would like to pursue that. But I think we do need to know, and we do need to have some ability to control what's being installed within our borders.
And we'll take a look at that issue and see what authority we have.
I mean, the example that you just offered with the one on private property in an easement, I mean, who would even have standing to enforce the restrictions on that easement? Would it be this? I mean, the city wouldn't have standing, right? It would have
Well,
to
I
be
mean,
the private property owner.
the city is the owner of the property.
Oh, and so it is the city-owned
Yeah,
property.
it is the city-owned
Okay.
property, but
It's
there's an
proprietary
easement,
as
yes,
opposed to
yeah.
right. Gotcha.
Yeah,
Okay.
but there's an easement to Pepco.
Gotcha. Okay.
In other cases, the regulation would actually be in the zoning code, because they are on private property, whether it be property owned by the city or property owned by another entity. So the zoning code already regulates those easements. And the difficulty is some easements are granted to all utilities, and some easements are granted specifically to specific utilities. So Pepco might have its own easement on one parcel, but there might be a general UE or a utility easement that everyone's in on other parcels. So those are all regulated by the zoning code and what you can do in them. So I do think we can look at it again, but there are pretty good regulations that no one could just go and put up a pole in that easement with it, partly because most of those are in underground areas too.
I mean, even if we don't have control, for example, it is in a county right-of-way, I personally would like to know what's installed in the city. So I know there's some on Muddy Branch, we just mentioned. I saw the one on Quince Orchard Road go up. In fact, I think they're still working on, I saw some service trucks there the other day. I think I would like to see information on what's going in, where it is, why it's there, even if we don't have control over it.
We do have a fairly good understanding with the county that may not be the same understanding we have with SHA, because like some of them will be SHA too. It's not just county parcels or right of way that could be installed in. With the county, they've indicated they would notify us when they have applications or pending applications, We have not received any of those. We do not have that same agreement with SHA in terms of 355 or 124.
Well, we can make the request and see.
We can make
see
that
what we get.
request, but I can't guarantee you we'll have the same response.
Right. No, there's no, I mean, they don't report to us, but we can make the ask. Did you have a question, Aaron?
Yeah, Shelley wanted to say a quick thing.
Please come up to the podium. Please come up to the podium so you're on the microphone, and this has got to be very quick.
No, it's really in the nature
Wait till you're at the podium. Okay, now.
In the nature of a question, I mean, most easements are